Nobody really gave an answer, so I don't know that it's clear.
All right. Well, with that, we'll power through. And like I said, we will be available for probably about 30 minutes or so after we get done with the class portion. So if you guys have questions or you just want to talk to us, so you can, ask why Felicia's a better lawyer than I am, things like that.
Well, that'll become obvious through the 4 weeks, so just wait.
Thank you, Felicia. Well, they won't know till then. So anyway, Felicia's going to start off because ladies first, and let's have some fun today.
Okay, so I'm going to go ahead and start with the basic foundation that you all have. Watched the video, filled out the outline, and did the homework. So you all should be familiar with our good friend Ronald Smalls. And I want to start talking about when you first get the case. I know that we went through step by step what you would do through each week. But when you first get the case when trial by peers, you're going to want to read through everything. And I'm hoping that all of you have read through all of it. If not, I have it open here. I have read it. So we can, I will be answering questions if you have specific questions, but speaking of questions, I want to talk about what things jumped out at you as you read this, because that's what's going to be your first thing when you grab a case from trial by peers is what do you want to know? Okay. I did have the opportunity to spy one person's homework and mention something about whether or not Ronald Smalls had a history of being violent. I thought that was a very good question that you would want to know. Does anyone else have questions about what you would want to know? Okay, if no one volunteers, then, I see the chat now. If no one volunteers, then I can, go ahead.
Yeah, so you're on the audio on this. You need to charge it. So if you can hear me.
Can you repeat that?
So it sounded like he was asking if we could hear him, and we could. So there are some questions in chat as well.
Who threw the first punch? That is such a good question. I really, really, really like that one. And the way I could tell, that one, I hope you guys notice that the boys have different versions, right? Ronald and Michael have any altercations before the fight? You mean before the flag football game? Like, why was he just being aggressive at flag football? Right. These are all great questions, guys. And these are all stuff that you would want to ask when you're prepping this case, and you're going to want to put these facts into your arguments. The questions about the witnesses. So if you guys noticed in Mr. Small's statement, which was small, he didn't mention anyone else, but in the other boy, Michael McKinney, he mentioned his two friends, Perry and Kenny. That would be interesting to see what their perspective was, or to find out if we could get information from them. Whether or not the brother showed up, that's true. So I'm trying to read these, but you guys are jumping in, so it's great. I also would want to know if there was any animosity between the two beforehand. That's another good question. Cameras. So yeah, schools, at least I think at the bus stop would have a camera, but definitely if there was any video, you would want that as evidence, and we'll get into evidence later in the week.
So one question I keep seeing a lot of is it sounds like it's breaking down into, was there any past history or any history between the two? Is the first kind of group of questions I'm seeing. The second question I'm seeing is who started the fight? And then we're seeing other evidentiary questions, like are there witnesses? Is there video? There's issues about a gun. So one question I have for you guys is, maybe let's take this Let's take this one category at a time. So why would it be, is it important who threw the first punch? Okay, does somebody want to explain to Felicia, Alexi, and I why it's important? So why don't we do this? I'm gonna pick someone here so we can get some talking. How about Nicole Miller? You said it's important who threw the first punch. So why don't you tell us, unmute your mic and tell us why you think it's important that someone threw the first punch.
I think it's important to know because this is the person who started the violence, and it could be self-defense for the other person if they did not throw the first punch.
Okay. Now let's find someone who said no. Lexi, why don't you pick someone who said no?
Sabrina Peterson, you said no, so go ahead and mute yourself and tell us why you don't think it's important who threw the first punch.
I said no because sometimes in fights it can be like egging it on, and so then sometimes people just snap, but they're not like initially starting it because both boys might have been intending to fight each other, like getting in each other's faces. So it's been enacted by both sides. And
no, I get where you're coming from. That makes sense. That's also a good point of view. Let's see what else people said.
So Felicia, do you have any follow-up to that? Because I think you know where I'm going with this.
No, you go ahead.
Okay. Did anyone in reviewing, and this is a big part of your case strategy, did anyone take a look at what the charge is in this case?
Oh, you all did. That's brilliant.
So let's pick someone here and make them speak. We'll go with, I can't see your whole name, unfortunately. Victoria Tremillo dash, it cut off.
Yeah, Romero. I have two last names.
Okay, yeah, it cut off on the chat thing, so I couldn't see your whole name. So why don't you tell us, so you said it was a fray, which is correct. So why don't you give us your theory? So first of all, do you think that who threw the first punch is important or not?
Well, to go along with one of the girls that said, I understand that if Smalls threw the first punch, then he would be considered the aggressor. But if he was defending himself, then it would be self-defense, which is a good strategy to use as a defense.
Okay. So you're saying that the first punch does matter in a fray?
Yes, it does.
Okay. So let's take a look. So see someone who said no, and they can make their argument. Who wants to be a prosecutor and says no, it doesn't matter?
Did you see one that said no?
I saw a couple, but it's gone. Okay, so Samantha, you get to go first. So Samantha, you're a prosecutor. You get this case. You're prepping it, and you see a fray. To explain to me why you think that it doesn't matter who sent that first punch.
Okay, so it doesn't matter who threw the first punch because a fray means disturbance of the community, disturbance of the peace. Therefore, it doesn't matter who threw the first punch because we're talking about the peace and the disturbance that it caused, the fight, and how the fight disrupted the students and etc. So it doesn't matter because it doesn't matter who threw the first punch because it disrupted the peace.
That's good. That's good.
That's very good.
The prosecutor in me says you're exactly right.
Well,
But see how the point of this exercise is to show you guys all how there could, using the same language and the same set of facts, you pick up pieces of the facts and argue both sides. In the law, everything can be argued both ways. The best attorneys are not the ones that yell the loudest or the ones that quote the most law. They're the ones that are able to see things from both sides, because that's where you get into the anticipate your opponent's arguments piece of it. And with what she just said, yes, someone could have thrown the first punch, but it doesn't matter because you kept fighting and you disturbed the school or the peace. And that's what the affray citation is referring to. So both good arguments, and they would be hopefully what you would argue on either side of that, of this citation for this case. So in developing, so let's develop some strategies. I heard self-defense is a good strategy. I just heard fighting is a good strategy. Does anyone want to expound on the idea that it doesn't matter who threw the first punch because the fight, they both willingly fought? Does anyone disagree that they both willingly fought? No, okay.
And feel free to speak up. I mean, that whole listen, part of being a lawyer is there is no real right or wrong. So if you honestly feel like, you know, to answer Felicia's question, if you honestly feel that way, go ahead and speak up. Like there is no wrong answer. It's what you can, it's how good you are at making your argument. That's the fun part about doing the legal stuff. So feel free to speak up. If you're the only person with one opinion, you may be the only person that wins in court that day. You never know. So go ahead and speak up.
So I like Zachary's point, and maybe you can unmute and expound on it, that it's possible that Smalls did not engage in the affray willingly because of the gun threat. Oh, you have no microphone. Okay. So they're going to have to type it to me. So before we move on to what would happen before the fight, I want to examine that idea, because that would be linked more of a defense side to a self-defense. Does anyone else think that I'm going to bring my brother to shoot you would put Ronald Smalls in a reasonable fear for his safety?
Oh, we got differing opinions.
Oh, I love it. Okay, so I saw one, and I'm just going to call out a name I saw, Nicole Miller. Wait, we already called on you, didn't we? So let's see. Samantha Lucas, you said yes.
Did we already call? Oh, yeah.
So
Yes.
why did you say yes?
I said yes because if you're being feared for your life, especially with a gun, well, he hasn't gotten his brother yet, so you're going to try and defend yourself so that you can injure the kid before he gets his brother and shoots you. So that's how I see it, and I would be scared if someone threatened me with a gun. I mean, I know some people are saying no, you wouldn't fight him because you're scared, but, like, you'd fight that kid so he doesn't go run and tell his brother. You know what I mean? Yeah.
Yes. Yes, I do. That's good. And then I just picked up one before it disappears, that he could have warned an administrator about the gun threat. Does anyone think that changes, that idea changes the perspective? So let's say for a moment, he has a reasonable fear for his safety, as she just said, because, hey, he's going to shoot me. I don't want that to happen. Does it matter that he didn't tell anyone about it? He just fought with him then. Well, which would have been the second fight, the one he's cited for. Good. Do you think, and if it matters, a lot of you are saying yes, if it matters, Alondra, why don't you explain why you think it changes the whole story? Because that was my next question.
I think it changes the whole story because it makes it look like he's more mature, which is always a good thing, I guess. So, for example, it's like it's kind of like he kept letting it like lead on, versus if he would have just told like a person, an adult, they could have done something, so it wouldn't have gotten this far. And I think it's really interesting how both people like kept it so personal, like they didn't tell anyone else, almost like if they didn't have a support system. So I would try to make something like they were I don't know, like almost like lonely or something, because they didn't tell anyone else, so they kept it very personal, if that makes sense. I don't know.
Yes, it does. So So that would mean that they wouldn't reach out to administrator. Maybe the administrators are not approachable. So they didn't feel
Yeah.
like they had somewhere they could go, and they felt like maybe they had to resolve the issue themselves.
Yeah, and it also goes like based on the school that they go to, because lots of schools take it different ways. So like lots of schools are like, oh my God, we have to report this immediately, but other schools are like, oh, just we're gonna protect you, but they don't really do anything. So I think it also goes a lot with like how the school does their own thing.
That's important too, and those are definitely information that you'd want to find out, because you have to look at everything when you think about, was he scared for his safety? Does he have a defense here? Should he have gone to someone? Is the staff supportive? You're going to want to know all of those things on actually both sides. But these are all great questions and great strategies. I'm glad that you guys are really thinking about this seriously, because a fray is a case that we get a lot in trial by peers. So
I'm seeing a couple of interesting points here. First of all, Siri, be ready to argue your case here, because you're disagreeing about talking to an adult. But one point that I actually found interesting was something that Brenda said, and as well as McKenna, about maybe being afraid, not wanting to talk to administrator, not wanting to, feeling a little intimidated. So I understand that when we're trial by peers counselors, you're gonna be assigned to a side essentially, but sometimes you got to take your lawyer hat off, and you need to put your counselor hat on, and you got to realize that if you have someone who's in that situation, this is where restorative justice stuff comes into play. While they may be scared or intimidated, what if the gun threat is real? Do you want that person taking things in their own hand? Do you want your client, if you're on the defense, taking things into his or her own hands and potentially getting injured? Or do you think it's better to talk to an administrator? So this is where you have a very awesome responsibility as a counselor, not just a lawyer, to talk to your clients and let them know what they while it may not impact the current case, it's like, okay, from now on, if something like that happens, you got to go talk to an adult, because especially nowadays, you never know who's being serious or not when it comes to firearms and things like that.
So you said you wanted Siri to...
I do, because Siri made the opposing side comment to Alondra, and I'd like to see what their argument is.
I said I disagree, because he could have been scared to tell, because maybe the threat was real, and him telling would just make the brother want to come up there more and actually shoot him if the threat was real. And then again, he should have told, but he shouldn't have went straight to administration, because sometimes at schools they don't believe what you're saying, or they don't take you seriously, like especially if you're a kid who does get in trouble a lot, or you you're always in the office or something. They won't believe you, or they won't take you seriously, so you have to go home and tell your parents, and then they take it to administration, and they probably have you stay home so that you're safer that way.
That's good.
Yeah, that's a good point. I'm watching you guys discuss on the side. I'm glad you're chatting amongst yourselves about it too. None of these points are wrong. These are all great things to bring up an argument, and I'm going to use this as a little bit of a segue here, but these are all things that you want to think about when you're developing your case strategy and how you want to prepare your case to take into court or to discuss with your clients.
Absolutely. You want to, because the more you think about it, the more prepared you're going to be, the more you go over stuff and figure out, hey, wait, that doesn't make sense. And thinking about it both sides will help that. So I'm reading a lot of really good arguments about talking to the administration. So I would definitely, it goes back to that original point, how would the administration react is, I feel like, something that you would want to know. Let's see. Is there anything else in the case file, and I'm looking for something specific that anybody thought that they would question, that they read that they would question? Oh, does the brother go to the same school? Oh, that's a good question too. So, okay. I just want to point out here, when you read through the two statements, and this is something I want you to do when you get them. Good job, Sabrina. That is one of the things that I noticed that McKinney said that Smalls didn't. And did everyone see that? He started his talking. So, two things. McKinney actually says this happened on Thursday, and then the very next day was the assembly. For some reason, Smalls says it was all the same day, and the police report says it's all the same day. So that was really weird. Like, why do you have it on different days? And that's a weird kind of fact that you'll find in real life that you're going to want to kind of explore and figure out to see who's making the mistake. But he said he called my best friend, and her mom answered and said that she died. So I was already mad, and we were playing flag football. So I don't know when that phone call to the best friend came in, but he was mad, and now they're playing flag football. And Ronald says in his statement, they were just playing football. So something obviously happened when they played football. Obviously, the victim says that Smalls was getting angry or tackling him. But the fact that McKinney identifies himself as angry before the flag football, that might color how that went down. Was Smalls really being that aggressive to make McKinney that mad at him? And what part did the other side play in that, in terms of I don't think, by the way, let me just stop here. I don't think the kid died. I think the mom told the kid that she died. Because why would you be mad? I think it's just the mom not wanting the kid to talk to her daughter. So I don't think anyone actually passed. I think it was just some mom not wanting him to talk to her. And it's good. That's right. So if this crazy tackling happened in flag football, how come nothing happened? Was it who would be allowed, or isn't someone supposed to be watching them? This is not supposed to be allowed. These are all great questions that you can find out just by talking to people, and figure out what's going on, what part of this is reasonable and what part isn't reasonable. How about the fact that they were, I want to answer one quick question. I want to point out something that someone asked that I think is really big in every single afraid of fight case that you have. And they were asking about height, weight, size. And on the little statement reports, it does give you an idea. So Ronald Smalls is 13. He's 5'9", 155 pounds. And the other kid is no age, 5'5", 120. So they're roughly the same, but that's a good point, because, and I'll just tell you a quick story about a trial by peers case I had. Oh, you see he's 16. Wait, you're saying he's 16? Oh, that's his race. I'm sorry. I thought that was his age. No, that's a B, not a 13. So then they're the same age. Well, they're in the same class. The years are whited out on my copy. Let me go back up here. Anyway, oh no, here it is, 99, 16, and it doesn't say for the other kid. So if they're in the same class in PE, they'd be roughly, you think one is 14 and the other is 16?
No, it says on the thing, one is 16, one is 14.
And they're in the same PE class?
Yeah. Smalls is 5'9", 180, and McKinney is 5'5", 120. It's on page 7, the arrest report.
If there's typically age differences in different classes, so that might have been why they were in the same place and the age difference.
It's interesting to find.
School too, so.
Yeah, it's interesting to find the discrepancies because in the statement the kids wrote, they're both 5'5". 5'9" and 5'5". Okay. So yeah, you're going to want to go off of what the statement said. So my point being, the size of the child is extremely important relative to each other. Because if one kid is saying, hey, he bullied me on the bus every day, and one day I just couldn't take it anymore and nobody's ever been helping me, and I turn around and hit him. So we took that case to trial, the bus battery case, and the prosecution had to prove that the child hit the other child. And we had someone on the bus that said, yeah, I saw him hit him. Here's the thing. They argued self-defense. The victim got up and testified. And then we're looking at the defendant, and the victim is easily twice the size of the defendant at that time. So does that matter? Well, it mattered to that particular jury because that kid was found not guilty. So that is a very good point, because you got to look at it. These are a jury of your peers, guys. These are people who think the same way you do. And so is a story more believable based on their size when you're looking at a fray or a battery, about what choices that kid had and what reasonability of his being afraid. So, and those are all things that you pick up here throughout the case. So I want to talk about maybe who would try to subpoena the two friends, Perry and Kenny. Anyone interested in what they have to say?
You mean like who, like the defense or prosecution, or like which one of us?
Which one of you?
Okay.
So would you want to do it as the, let's start with, would you want to do it as the prosecution?
If Ronald, whatever, if like, I guess the main thing is that I guess like the main theory, I guess, from McKinney is that he started the fight. So yeah, I'm assuming they'd kind of take his side. Regardless if they go against what the prosecution thinks. So
that's a good point. That's a good point. So did you think at all about, so when he says, today, 2-5, he was with my best friends, Perry and Kenny. I walked up to them and said, what's up to both of them? Then they start talking about, oh, you lie so much. So this is McKinney's two best friends, right? But they're hanging out with a guy that he fought with the Friday before. That's why I was really interested to see what they said. So would you subpoena them? You're right, maybe to see what their position would be, but you definitely want to try to get a hold of them and find out
what they saw, like what they thought.
Yeah, perfect. Right. So another question was the relationship between the two before the fight. Does anyone want to chime in on that? Does it matter what the relationship was?
In their statements, they don't say anything about like prior arguments or like any other issues with each other until like those specific 2 days. So it might not be a plausible argument to bring up like things from before if they didn't speak about it then and say, this has been building up and it was like bound to happen at some point.
Would you at least ask about it?
Yes. It's just based on the case. None of them have said anything about bullying or just like picking on every now and then. So it might not make much sense to just all of a sudden bring it up after it didn't seem like it was the reason for the fight at that time.
Right, right. And that's why I started out this whole exercise with what additional questions you would want to know. And that's why we began the discussion with, hey, what other stuff would we want to know? Because you are right. You're giving a very limited amount of, you're given what they had chose to write out. Sometimes, what if there was no statement at all, right? You're going to want to know what your side of the story is. So you're going to have to figure that out in order to develop your strategy, right? And that's why when you first get the case, the first thing you want to do is figure out what don't I know? What more information do I need to develop? So when we move on later on to the later part of the homework, that you're going to obviously be arguing off of what you have. But this is the most important part of case strategy, is trying to figure out if there's any other information that you're going to want to use or that you need. And I see a lot of back and forth about whether or not it mattered, whether they had animosity for a long time. So that is something important that you'd want to ask about. That's an interesting question, Alondra. Does reputation matter? So if one of them was known to be an aggressive kid or a fighter, it would obviously make any threats that kid was making seem scarier, right? Why do you say it depends, Siri?
I think it depends because, like you said, it could depend on if they have a reputation for fighting a lot or for beating up kids a lot. But at the same time, it doesn't matter, because regardless of that, if they have a reputation like that, that doesn't mean that they're willing to fight just anybody, or they're gonna fight them because he's playing around or tackling him, or that he likes to fight all the time. Maybe he just ends up having a lot of problems with people, or people don't like him and they end up fighting. So at that point, it just doesn't matter about his reputation anymore.
Okay, that's a really good point too. Really good. So I'm hoping that you guys can all see that as you read through this and start thinking about things, that it's just really important not to procrastinate on this kind of stuff, because the more holes or pieces of information you identify that you want, the longer you have to collect them, the easier it is. I don't want to belabor too much of what you guys saw the video. You figured out what you need to do to process the cases. So I want to move on to the next question that I had for you. And some of this stuff goes into that, is why is this a good case for a mediation diversionary program as opposed to a trial?
I actually would like to break in real quick. I know she already asked the question, but I do have, before we move on, I have one more question for you guys. So we spent a couple minutes looking at discrepancies between the police report and the statements with regard to the information, age, height, weight, all that stuff of the kids. So let's just say you have another case where you've got the same kind of issue. Can anyone think of how that they may use that for their case? That the official documents are different than the statements that are being made? So these are all the good points they're bringing up. We're going to learn something later down the road when we're discussing evidence and witnesses. I just wanted to bring it up now to keep your attention on that. If you see things like that, and when you're doing your case prep, keep an eye on it, because that's stuff you can use for arguments and evidence, that there might be what's called inconsistent statements. There's also just, it damages the credibility of that evidence or that witness. So if you see things like that, keep an eye out for it and make sure you note it. That's not something you just, someone made a clerical error. Well, if they made a clerical error here, where else did they make errors? So you just want to keep an eye on that stuff. So anyway, Felicia had a question about ADR and mediation.
Right. And I already saw a really good answer about if Ronald Smalls had anger management issues, he could benefit from an anger management workshop. That's true. It's so true, in fact, that I think he should do that either way, whether that was in a mediation program or whether that was through the court process. because at the very least, he was perceived as being very rough playing football. And I saw a question earlier, but I lost it. You guys have been very communicative, which is great. But the question was, why are they fighting twice? Something's good. I feel like I get the hint that something is going on, because it wasn't just enough to fight at the bus stop and get a citation and a warning. They fought again. So I think the definition of playing rough was all the tackling, right? Someone asked about what is playing rough. So in the mediation setting, another reason this would be a good candidate for that is because we can get to some of the root of these issues, like what was he doing? Have the McKinney child say, this is what I thought you were doing that was too rough at the football game. It's flag football, you're not supposed to tackle each other. You could explore about maybe, McKinney already being mad and how he felt about what was going on. That's an interesting point about both kids kind of being in the wrong. So how does that make that a good case for like a mediation setting where you're all talking? So Patrick, if you can unmute.
So you guys can hear me, right?
Yes.
Okay, so it makes sense for it to be in a mediation setting, because the way I see it, McKinney should not have threatened to involve his brother with a gun, but at the same time, Michael should not have fought McKinney. He should have fought the brother directly to neutralize the threat. So in a sense, McKinney's wrong for threatening to involve a weapon, and Michael is wrong because he fought the wrong person, in my opinion. So it makes sense for both of them to just talk it out rather than having to go to trial.
That's good. What do you think about the fact that they already fought at the bus stop before the brother got involved?
Like the second fight, right?
I believe the first fight was at the bus stop, and the second fight was when he said he was going to bring his brother to shoot him.
Because looking over the evidence, I thought there was the first one. They had like, McKinney was held back by like his friends, but then the second one I think was at the bus stop or something. I don't know. I think the evidence, but either way, it looks like both sides are an aggressor in this situation. So they're still in the wrong, because McKinney had to be held back. In that case, it was clear that he wanted to fight, but in the second one, it was then Michael who wanted to fight.
No, that's good. That's good. Does anyone else have any thoughts on the two fight aspect? So I'm going over it real quick, and let me just clarify. So after the assembly on Friday was when they got into it at the bus stop. Ronald Small says, or subject minor says, he went to the bus and the other guy got mad, so he wanted to fight me. I was like, I'm not going to fight you. And then he pushed me, so then I took off on him. So Ronald says he was pushed at the bus stop. McKinney says, I was walking to the bus and he snuck up from behind at the bus stop. And then later is when the friends were there and the threat about the gun. So it looks like there's some continuing animosity, at least between these three incidences between these two. So it's good that we asked about their history, because this seems like a lot for a flag football game to start all this animosity. So in a mediation setting, you'd be able to get each child's perspective on what's going on from them directly, with, of course, one of you guys peer advocating. So getting their perspective would be important. I'm reading to figure out what's the best outcome for the two kids, because maybe they both could use anger management. Going back to what Patrick said, like they're both aggressors. Maybe they both could use a workshop to keep this from happening again.
And I'm going to jump in real quick and address a question I've seen from a couple of people. I know Beza, and I'm sorry if I murdered your pronunciation of your name, asked it, and I saw a couple other people ask it as well, as to why McKinney wasn't charged with the fray. It's possible he was, but I just didn't get in front of the trial by peers program. And that means it would just go to delinquency court, just like normal charges do. Sometimes you'll see that there was a fight, person 1, person 2, but you only see person A having a fray charge. It doesn't mean the other person wasn't charged with the fray. It just means it didn't make it trial by peers. So just to address that real quick.
Or adding on to that, it may be in trial by peers in a different courtroom, because we've had that. But actually, I'm pretty sure, because usually Lexi and I work the same nights, where I'm in one courtroom with one of the kids who got in the fight, and another courtroom has the other kid who's in a fight. So just because you have, Lexi, that's a very good point she brought up, just because you're dealing with only one of the kids doesn't necessarily mean that. So that's an excellent point.
Okay. So
It says I just looked in the case file, it says the other guy, like McKinney, was charged with a fight. It just doesn't, the case is just for Ronald Smalls, so.
right. So either McKinney has his own court night, because you want to keep them separate, right? Because that wouldn't be neutral to have the same jury consider both of them.
Yeah.
Yeah. Either he's on another night or he's in the delinquency system. Does anyone else have a thought about why this would be good for the mediation program? And that would be kind of the kids with an advocate in a group sharing their own perspectives.
Xzavier, I saw you wanted to say something. Why don't you go ahead and unmute yourself?
Okay, can everyone hear me?
Yep.
Okay, so this is going back into what we were talking about earlier about the brother bringing the gun and things of that nature. Just a question that's been constantly on my mind. Would we like to know the background of that family? The fact that the brother feels comfortable enough to bring his older brother with the weapon to solve the scenario. I mean, don't you think you guys have to you have to really be comfortable? Like that has to have happened before, or you have to be used to that type of thing? Because you just don't wake up one day and be like, "Oh, my brother's gonna come." Don't you think there's something going on psychologically at home or in the background that can possibly play a part in what led up to the altercation as well? The fact that he could come from a very violent or abusive home, where now he's taking out on the students at school.
Yeah. Sorry, I had to. I think that's good information to know whether you're going into mediation or into court. And I think especially as, well, prosecution or defense, but I think if you're the defense, I think you can research that, see if that's something you want to bring up as a mitigating factor when you're arguing for either sentencing or for the case itself.
Okay.
And I just saw another reason to bring it through the mediation program. And I hope I'm saying your name right, Assis. It's better if they talk to each other and try to solve it among themselves. And it's clear that there's something going on between the couple of fights. So I think that's a really good point, is if they have the opportunity to talk straight to each other, which would not happen in court setting. That would only happen in a mediation setting. Any more on mediation, Mike?
Yeah, I think, I personally think this case is definitely a very good candidate for alternative dispute resolution or mediation. Like Felicia said, you're not going to get trials in court is usually adversarial. It's one side versus the other. Mediation is a lot more collaborative, and you guys will learn more about this as you go on in the program. But it's very collaborative. Everybody sits down. Everybody kind of gets to see their side of the story. Everybody gets to kind of feel what the other person saw. And, you know, at the end, even if you may not really agree at the end, at least you see somebody else's side. I see Patrick said it should be easy to go through ADR. Not necessarily. Maybe you've got one person who says, yeah, I'll sit down and talk. The other person says, absolutely not. I did nothing wrong. I don't think we need to sit down and talk because I disagree with you. So it may look like it, but you have to have, like, it's like a forced apology. You don't want two people in the room to force them to apologize to each other. You want them to come to it, you know, come to the table wanting to talk. So while the case itself is a good candidate, you may not necessarily have the parties agreeing to do that. So, you know, this is just a good candidate for that, because it's more of like we had a couple people saying they're both kind of in the wrong here, and 9 times out of 10, if not 9.9 times out of 10, affrays are kind of two people being in the wrong. So they're very good candidates for alternative dispute resolution, and that really goes back to our restorative justice model of, you know, recognizing the harms and repairing them. And in this case, maybe they have something going on. Maybe there is a pattern. Maybe there is something that if they sit down and talk it out, they'll stop fighting. So again, you'll learn more about mediation down the road, but we want to at least expose you guys to it to kind of get you thinking when you do case prep, maybe this is something that can go through that program. But not necessarily, because not all cases end up going through that.
And I think you guys are doing a very good job of, and I'm going to borrow a phrase from one of my undergrad professors, of looking around the lantern. So you want to look at it from, you know, from McKinney's side, from Small's side. You want to have an understanding of both the defense and the prosecution, no matter if you're in mediation or if you're going to court, if you're the state or you're the defense. Having an understanding of the whole picture will help you, A, make a better argument, whether you're in court, in sentencing, or in mediation. And B, it will help you anticipate what the other side might bring up so you can counter it.
Mike, Zachary asked a good question. Do you want to address that?
My opinion is because if especially the idea behind alternative dispute resolution is to actually engage, and restorative justice specifically is to actively engage as many people as this touched as possible. So you wouldn't necessarily want to limit it to the 2 people. Maybe when you want to get the parents involved, this is going to affect them. Now they're going to have to drive their kids down to trial by peers. You may have had, you know, they have to deal with this. They have to talk to school police. It's taking time out of their day. They've been harmed. You may want to talk to, you know, if this happened in a school setting, you may want to bring the administrator in to discuss. You know, a couple people brought up, you know, that someone may not feel comfortable talking to a school administrator. That's a problem that you can solve in mediation. You know, you can bring a school administrator and let them get their ideas and their viewpoint off their chest and explain, hey, you can come to me with these things. You don't need to be afraid of me. I'm just a regular person, you know, that's trying to help you. So I think that you definitely wouldn't want to limit anything in this case. If anything has been touched, and this is where Alexi's point about looking around the lantern, I'm going to steal that. That's good. I'll use that in court. You want to look and see, okay, here's my case. Who has this event touched? You know, and you can even make a diagram out of it. You know, here's the event in the middle, put some spokes around it. Who has this event touched? Parents, the school, possibly other students. Maybe McKinney and Smalls have friends that may be this affected. So anyone that you could bring up and bring this into that can potentially help diffuse the situation and prevent it from happening again, as well as maybe repairing some of that harm, is a good candidate to bring into mediation. So to give you a real world example, in the mediations that Felicia and I do, I don't remember the last meeting, and we have, let's just say we have 2 parties. We have the state, and then we have a set of parents. I mean, when's the last time you had a mediation, Felicia, that had less than 9 people in it? Because I can't remember. Yeah. So, you know,
My next one is set for 12.
Huh?
My next one is set for 12.
Oh, God bless you. Well, so there's a perfect example. So you're going to bring multiple people, and anyone the case touches is a good candidate to bring in the mediation, because you're going to want their viewpoint in, and that the more viewpoints is going to add into the discussion. I would say the only time you really want to actively exclude anyone that's not a party is if you don't think their presence is going to help. Let's just say you've got a case where it's a theft. Someone robbed a 7-Eleven. You know, they shoplifted some candy. And you want to include the store owner in there to get their point of view, because, hey, yeah, I know 7-Eleven's a big name, but this is my only store. So everything that gets stolen from me, you know, that's less, you know, profits I get, less, you know, money to put food on the table for my family. So you maybe want to get that person in there to say, to show whoever the subject matter is, like, this impacts more than you think. But that store owner is just angry. He just wants to walk in. Nope, I want to accuse this person. I want to go after them. They're wrong, they're wrong, they're wrong, they're wrong. Maybe you don't want to bring that person. That's the type of, that'd be the only time I would consider excluding someone. Because if it's going to derail the mediation, then that's where it damages it. Now, if you have a party acting like that, it's probably not going to go to mediation. But if you've got someone who's a part of the community where everybody else is in agreement, hey, let's sit down and talk, and you've got this one person who's just, you know, angry, that would be someone you want to exclude. Lexi, Felicia, do you have anything to add to that?
I'm looking at Kiara's question, and you can type an answer if you want. When you say people working the case, do you mean you guys as peer counselors? Do you mean us as, when I say us, like Mike, Felicia, and I as your senior attorneys? Yes, you as peer counselors will be there. You'll be there as advocates for either the subject minor or the community. So you'd kind of be acting as the state, but not really. You're there to advocate to restore the community and make it whole. So you guys will definitely be there, and us as senior attorneys, we will also be there as well to make sure things don't get out of hand or people don't start yelling at each other.
We're there to mediate.
Yeah, we're there to mediate.
So, Felicia?
Would you want to address the nurse question? Bringing the nurse to see how bad the injuries were?
Well, how about this? I'll flip it back around. Is it Taya? Taya, why don't you unmute yourself and you tell me if you think it's a good idea or a bad idea for the nurse and why?
I think it's a good idea to bring the nurse in because McKinney said that he got hit in the head, and so that would be valid, or that would be important, because if Smalls really did sneak up on him and hit him in the head, then you would be able to have the nurse say that he did it, and so it would be like, hey, okay, Smalls threw the first punch, so he should, so it's like he abbreviated McKinney.
Do you think that's a better person to bring in as for mediation or as a witness in trial, or is it equally?
I think it should probably as a witness.
Okay. I think that's a good answer. You know, if that might be something you want to consider as an attorney, if you think that the nurse is going to come in, and you know, I see there's some different opinions about what the nurse found, but if you've got, you know, if the nurse is just going to come in and say, oh my God, these injuries were horrific, you know, you have to think, is that a person you want into mediation? Were they harmed, or was it just them doing their job as the school nurse? I think it's a great witness for trial. I don't know if I would bring that person into mediation if they have nothing to add. It just depends on, you know, the facts of the case.
Okay, so I want to move on. Guys, we're already at an hour in, so I want to move on to the sentencing arguments. I asked you guys to do this because, as in real life, approximately 97.9, and that's very approximate, percent of your cases are actually going to be guilty pleas. So it's kind of like, I think it was Patrick said, it'd be easy to find the kid guilty because he did disturb the school. So say you're the peer counselor, or you're the prosecution, and the subject minor's counselor went over everything with them and said, hey, you were fighting, and the subject minor, who has the right to choose, decides to plead guilty. And so that goes down two ways. And we went over this, I think, in the handout from last week's, or the introductory week. If the subject minor chooses to plead guilty, you as his peer counselor, and then the peer counselor for the state, can either negotiate some terms and have it all worked out before we get to court. And what that means is communication back and forth, talking to each other as peer counselors to see what you guys would think was fair, bringing it back to the subject minor, seeing what his concerns were, what he would agree to. And we went over, I believe, already some of the mandatory requirements, and I know if you've read the material, it's in there, the mandatory, but I'll go ahead real quick. The mandatory requirements are between 8 and 40 hours of community service, 1 to 3 jury duties, and a workshop, and the apology letter. So you would have those components there. You could have others like an essay. But say you guys couldn't agree to everything, then you would need to do sentencing arguments to a jury. So we bring the jury in and have them listen to the arguments. And how that works is the judge takes the subject minor's plea of guilt and then moves on to sentencing. And then the sentencing arguments start with the prosecution gives their argument, the defense gives an argument, then there's a thing called a rebuttal. Because the prosecution has the burden, they get the last word. So part of your homework was to write one for each side, and I'd like to hear them. I know it's based on not all the good info we talked about today, it's based on what you had beforehand. Does anyone want to volunteer to give their prosecution sentencing argument? If you don't volunteer, I'll pick from random. Come on, it's not that hard.
I can share mine.
Perfect.
Okay. Good afternoon, ladies and gentlemen of the jury. We are here today because on February 5th, 2014, the subject minor, Ronald Smalls, was willfully involved in an altercation at school with a fellow schoolmate. Prior to February 5th, Smalls and he fought. According to the report issued by Officer Paul Carabucci, Smalls said on Friday, January 31st, 2014, McKinney and Smalls were playing flag football. Smalls played a little too aggressive, and McKinney took offense to that. Following the school assembly, Smalls and McKinney saw each other and fought. Officer Carabucci and his partner, Officer Lafredo, responded to the disturbance and issued a warning to both teams. A few days later, on Wednesday, February 5th, Smalls and McKinney fought again. According to the statement report, McKinney wrote, Smalls was the aggressor instigating the fight. Ladies and gentlemen of the jury, there is no denying that Smalls was being aggressive, and it's quite normal to feel frustration and defense when being targeted without knowing the reason as to why. Due to his prior altercation with the same student a few days before being arrested, we are recommending 15 hours of community service to further develop a relationship with his community. 1, jury duty to understand the process of being part of a legal decision making. 2, youth development workshop, one of which will focus on dealing with emotions and anger management, and a letter of apology to his mother.
That's good. Can you, one question, why the letter of apology to his mother?
Well, going off of what information is provided in the documents, it seems that he lives with his mother. There's no father figure present, going off of what stated in the legal documents. And so, going off of that, it's safe to assume that she's a single mother, and as a single mother, it's hard enough already to have to have to raise a kid on her own, and then to have a kid involved in a fight, it's always more difficult. So a letter of apology is more fitting.
That's good. And the only critique I would have, as I thought your presentation was good, I would add that into why the letter of apology to the mother, because those are good reasons. And those should be included to the jury so they know why. Because you want to make sure that your argument doesn't leave any questions. So, and you had great answers. So I would just include them.
All right. Thank you so much.
No, you did great. Thank you.
I agree. And the thing I'll add on to that, you did something very well that sometimes our more experienced peer counselors do, is I really like how you laid out, I want this many jury duties for this reason. I want this many community service hours for this reason. Too many times when we're in, I just say, well, I want this many hours, this many jury duties in this class because it will help them learn their lesson. I'm like, okay, how? Like, tell me how. So you did a very good job doing that, and that's a great job.
Thank you.
Any additions? Are you good?
No, I'm good.
I'm looking to see who said they would go next, but you guys were talking about something else.
We're just answering questions so you didn't cut people off while they were talking. It's about pleading guilty and things like that. So are we getting another prosecution argument, or are we gonna go right to defense?
There was one who said she would go. Let me scroll. How do I scroll up without skipping a ton of it? Ash, was that you? Do you want to give your prosecution argument?
I wasn't the person that said that. Hold on. I'll scroll up to see.
I think both Ash and Siri said yeah.
Yeah, I can't give mine. I think it might have been someone else that said it.
Okay. Well,
yeah, I can. Whatever. Yeah, I don't go. I can do mine. It's short though, so I'm in.
That's okay.
Should I do my prosecution one?
Yes.
Okay. I also didn't say ladies. I also didn't say ladies and gentlemen of the jury. What do you mean? Yeah, I'm not addressing it to anyone specifically in this. So I probably should add that. But the defendant, Ronald Swells, and Michael McKinney got into a fight, I think it was, at Monaco High School on February 5th, 2014, at around 7 a.m., which is the beginning of the school day. Mr. McKinney was standing and talking with his friends when the defendant, visibly angry, approached him and pushed Mr. McKinney, starting the fight. The defendant followed Mr. McKinney until the fight was broken up by two police officers. The defendant's initiation of the fight was illogical, and it was fueled by anger from an event that had taken place days before. Therefore, because of the facts of the case, I am proposing a sentence of 25 hours of community service, 2 jury duties, the anger management and decision-making workshops, and a letter of apology to Michael McKinney. The 25 hours of community service makes up for the full school day and workday that the defendant, Mr. McKinney, and the parents missed because of the incident, as well as the time missed due to the case proceedings. The jury duties allow the defendant to spend time on the other side of the law, and the 2 workshops are aimed at helping the defendant understand what he did wrong with both his anger and decision-making, which is the reason we are here today in court. Finally, the apology letter will make the defendant reflect on his actions and their consequences. He needs to learn that because of his poor decision-making, Mr. McKinney was also charged with a fight, and his life was affected. This sentence will allow the defendant to give back the time that he took from the community, as well as provide him with the right tools and knowledge to prevent him from ending up in trouble again. That's it.
That's good. And you know what, Ash, what's strong about your argument is that you don't have to go on for a long time. You can point out the most relevant issues and just argue those. And that's a great way to do that. I liked how you went through it again and reminded me which piece of your sentence was for. That was good too. So I like that because, as you know, as being a teenager, all of you guys are teenagers and all of you guys will sit on a jury before you take a case. You don't want to hear someone be too long. So the trick of this, and that's why I put the 5 to 10.
Sure.
Yeah.
Yeah.
Go ahead.
No, I just said sure. Thanks. Yeah.
Yeah. Okay. So you want to hit that magic window where you're long enough to be effective, but not too long. So that was good.
Okay. Thanks.
Good. And so there's some questions here I want to answer about, is the closing argument and the sentencing argument the same thing? No. A sentencing argument, the way we're using it in trial by peers, is the argument that the prosecution gives, like you heard these two give. Then the defense makes an argument for their sentencing recommendation on behalf of their client, which usually is lower, hopefully is lower. And then the prosecution does a rebuttal. A closing argument is the argument both sides will make at the end of a trial. We will get more into that on week 4. We have some stuff to do before we get there. I just wanted you guys to have the experience of this is what the trial by peers mostly does, is going through and reading these cases and making sure that you know how to argue them. Another question Angel has, is it appropriate as defense to include statements, claims made by the subject minor so long as you agree to it? Okay, Angel, I want to know, do you mean first, are they going to make something separate as in terms of a separate statement from your argument, or statements previously made? Can you unmute?
Hi. Yeah, so like I'm referring to like, for example, if the if within the defense the subject minor and his peer counselors have agreed to saying something within the argument, like for example, if I was the peer counselor, the subject minor asked me to say something on behalf of him.
So yes, and I'm glad that you picked this up because it's perfect to talk about it in today's forum. If the subject matter has a right to speak and the right not to speak, if they want to say something, they actually can say something separate from your argument themselves to the jury. You'll want, as the peer counselor, for them to review that and make sure that they it's appropriate. Because, and this has happened, that's why I bring it up, you don't want someone to plead guilty, move into sentencing, have the prosecution do the whole argument, have you do a whole argument in support, and then get up and say, well, I didn't do anything wrong. It doesn't look good. So you want to make sure that their statement is appropriate. Some kids are scared to public speak, so then you would be able to say within your argument, my client has something he wants you to know. He's a little shy and doesn't feel comfortable. He's a little scared of presenting it, so I would like to present it for him. And then you can do that as well.
Okay.
Okay.
Thank you.
Mm-hmm. That's a good question. Thank you for bringing it up. So Xavier's asking, will the charges be placed on the subject minor's juvenile record? So the trial by peers program is what we call diversionary. So what that means is they do enter a plea in our program. They do get a sentencing recommendation, and then the judge orders it. They can either follow what the jury said or change it a little bit. I will tell you 9 times out of 10 as a judge, I accept what the jury did. If I feel like it's off in any way, I do make adjustments. I know my other judge, Judge Sullivan, usually accepts it, but has made some changes in the past. And once they have completed all of the sentencing requirements that they're supposed to do, the charges are completely dismissed as if they were never filed. So no, it will not be on their permanent or on their juvenile record as long as they complete the program. The sentencing arguments should be directed to the jury. So the judge takes the plea, but the jury is usually sitting facing the judge. So what I would want everyone, and this is a great question, thank you, Juan. I want you guys to, and I usually say as the judge, present your argument to the jury when you feel ready. And that's because that's the group that is going to be persuaded by your argument is oftentimes behind you in the way we're set up, or off to the side of you. So you're going to want to turn and face the jury when you make these arguments, because that's who's going to be the decision maker. The judge just reviews their decision. So we've had two really good prosecution arguments. So does someone want to give me a defense argument? Right before you volunteer, let me just answer Lillian real quick. Both the prosecution and the defense should give their who, what, when, where, and why, or how, for their side. As we've already seen, you guys, and that's why I did that first, when we go through these facts as stated are black and white, but they can be interpreted on either side. So there's certain facts that are established. This happened on February 5th. But there, as we've all noticed, there are facts that are not established, like who threw the first punch. I don't know. They both have different sides. So where the facts differ, you're going to want to present them for your side, because the guilty plea is already done. You don't have to prove. Right now you're just doing, you're taking things for granted that are in the fact patterns that you're given. So as prosecution, you heard, I think it was Victoria go through and say this, he was upset, he got offended. She got that information from the facts. So that's what you would want to paint that. And obviously on the other side, you wouldn't want to show your friend Ronald Smalls as such an aggressor. So with that, Siri, do you want to give us your defense argument, please?
Ladies and gentlemen of the jury, as the report says, the offense took place at 7:17 a.m. on February 5th, 2014 at Monaco High School. On this morning, Smalls approached McKinney and pushed him, as he said in his statement, and that triggered McKinney, causing him to fight back. Assuming Ronald pleads guilty, he would normally have to accept the conditions of the mandatory sentencing requirements. However, considering the unknown facts of a prior relationship between the defendant and the victim, was there any animosity between the two? Why, when Smalls tackled in a game of flag football, was he not pulled out of the game? And if there was a displayed attitude of an overreaction of emotions from the victim, why was this not addressed? McKinney stated that he was already upset and angered by the death of a friend in his personal life. This statement provides an insight of the individual's frame of mind and is important to the case, and the authorities involved in the incident should have observed and explored a conflict resolution on their end as well, but therefore the outcome could have been prevented. Let's not place all of the blame on my client while not minimizing his clear, uncontrolled reaction in this incident of self-defense. If McKinney is accountable for his instigating actions in this case, it shows them both, the victim and the defendant, failing to uphold a moral code of conduct amongst its peers. McKinney clearly went to my client and mushed him in the face first, which then my client defended himself, hitting him in the face in return. This incident was broken by the hall monitors in the area, and they were both let go with the warning. The very next day, McKinney approached my client, threatening him and my client with getting his older brother there and shooting him. Yet my client is the one on trial here today. It is very clear that both the alleged victim and defendant made bad decisions out of anger, and the teachers or monitors involved in this incident should have dug deeper to help with the conflict between the two parties involved. There are no witness statements at all in this case providing evidence to back each party's claim of the events and how they transpired. With that being said, this is all hearsay. I believe that in lieu of my client accepting his part in being accountable in this incident, that should be taken into consideration, especially considering that he was clearly defending himself. McKinney continually made the situation continue to escalate even after the warning was enforced by monitors involved. McKinney kept provoking my client, and therefore is the reason Smalls had no choice but to defend himself. However, there is nothing in the report providing evidence of Smalls tackling McKinney while playing flag football. In the officer's statement, it states that he was playing rough. That does not mean that there was any tackling involved on my client's part, which would explain why my client was not pulled out of the game of flag football. McKinney's built-up frustration had nothing to do with my client at all, in which his own words of his situation clearly meant that he was already mad because his friend had died. Understandably, this explains McKinney's state of mind. Therefore, let's not excuse the alleged victims in this case, but mediate and guide both defendant and alleged victim to a more productive way of handling adversity and conflict. Thank you.
And Siri, what would your sentencing recommendation be for your client?
I'd recommend that he write a letter of apology to McKinney and anyone else involved, and maybe have the anger management classes. But I also recommend that both the alleged victim and Smalls have to write an apology to each other because both participated in things going wrong.
Okay, and what would you do for community service and jury duties?
I would give him 1 8-hour shift of community service and at least 1 or 2 jury duties so that he could see what it was like to see where everybody is coming from on the other side of the law.
Okay. What I liked about your argument is that you continually used my client, which is really good. You want to humanize the subject matter as much as you can. And you argued a lot of really good evidentiary issues with the case, and I like that too. And I can't wait to see what you do in week 3 when we really jump into that subject matter. But it was good that you picked up on all of those things. Just remember, when we're doing sentencing arguments like we're doing today, we have a guilty plea. So your client did take responsibility for his part. And I want to make sure that, I think you did reference that he took responsibility even though there was no statements backing it up. But we hit that a little bit harder. He's here, he's, realizes what he did was wrong, and, now's not the time to punish him kind of angle to it. But yeah, it was really, really good. And I think you pointed out a lot of really good pieces of information.
Okay, thank you.
Mm-hmm. Samantha, do you want to give yours?
Yes, perfect. Hold on, let me get it on my phone really quick. My apologies. Okay. Hello, Your Honor, opposing counsel, ladies and gentlemen of the jury. My name is Samantha Lucas, and I'm representing my client, Ronald Smalls. On February 8th, 2014, my client participated in a fight and committed a fray. Oh, hold on. As prosecution has stated, my client participated in a fight on school grounds and disrupted students. My client is a high school student who loves to play flag football. He also has a single mother who he cares for dearly. While he participated in fighting, my client understands the cause of the issue. He understands that he was playing a little too rough while playing flag football. While there was a second fight, Smalls was directly threatened and defended himself. With this in mind, the defense would recommend a sentence of 8 hours of community service because these service hours will further allow Ronald Smalls to understand that he cannot harm his community. By giving him an opportunity to help the community, he will be able to understand why his fighting disrupted the community's peace. He should also be sentenced to 1 jury duty to better understand his peers. By understanding his peers, he will further understand how to work with and talk to his peers. He should also attend 2 workshop classes that are conflict resolution and anger management. Attending the conflict resolution and workshop will allow my client to understand how to resolve an argument. He will benefit by learning how to communicate his feelings to solve an issue. Anger management will give my client an opportunity to control his anger and to understand why he shouldn't act on his anger immediately. The workshops will further help him more than many hours of community service. My client should also write 2 apologies letters, 1 going to the peer he fought with and 1 to the overall community. Writing a letter to the peer he fought with will allow him to bridge a mutual respect Oh, my apologies. Writing a letter to the peer he fought with will allow for them to bridge a mutual respect for one another and to dilute any issues they still have with one another. The letter will help both students feel more comfortable with one another. A letter to the community will allow for my client to apologize to his community as well as build the bridge again. My client understands the consequences that are being placed upon him due to his actions, which should be included in the letter to the community to show his growth. This sentencing benefits the community by gaining another member of society that can solve conflicts without disruption. Thank you for your time. I know I talked a little too fast, my apologies, but that's my defense sentencing argument.
No, that's great. That's great. I speak fast as well, so I have the same problem. But no, I liked it. I liked my client. I liked how you talked about benefiting the community. You focused on not being punitive, but raising him up. That's really good. All very good. That's actually better than some of the defense arguments I've heard from already seasoned peer counselors. So very good job.
Thank you.
I saw your shirt said ATEX, so I'm guessing this is your first. No, that's really good. I'm glad you shared. Thank you. And I wanted to make sure that I know there's a couple of people here that haven't really spoken up and are kind of listening as we go. So it's good to see that we can help each other kind of with the examples and stuff. And so I think you did a really good job. Thank you.
Thank you.
Okay. So we've had two, let me turn this back on. So we've had two prosecution arguments and two defense arguments and two very different approaches. And what I wanted everyone to see is how, as Mike said earlier in the law, there is no absolute right or absolute wrong unless you're lying, then that's different. But in terms of argument, in terms of the strategy that you want to approach, there's a lot of discretion. There's a lot of space for you to do something differently than someone else would do. So if you're listening to this and you wrote something differently than what these guys did, then that doesn't make it wrong. I thought both of those very different defense arguments were very good, were very effective. And so as you're listening to them, you can picture yourself as a jury and picture yourself as what you would have been persuaded by, what you would have thought was most telling, and kind of take that back to when you're going to write yours, what would convince you? And that's pretty much the number one thing I like to mention to you guys, is because this is peers. So you're not trying to impress some learned attorney or judge that already knows and been through everything. You're trying to impress upon either fellow peer counselors that haven't taken a case or kids that have been through this system. So I've been lucky, and I wanted to kind of give you a little bit of a cheat here. I'm lucky enough to have a teenager who I made volunteer with the program, and she played clerk. And so she would go back and listen to the jury deliberate and see what kids say. And I think it's really important to share that with you guys in the context of writing out your arguments, so that you know what is going to be persuasive and what you can't help. So what she would hear is so we get fighting, but we also get possession of marijuana quite frequently, unfortunately. Kids think because it's legal, it means it's legal for them when it's not. So you'll hear kids say, hey, I got 20 hours, so I'm not doing any less than 20 hours, and they have to be talked out of it. You'll hear kids say, I didn't think that mine was a big deal. This one's way worse. I'm going to give them something worse. Or you'll hear them say, hey, I got this. I think this person should deserve less. So they do use their own experiences. So keep that in mind. And the other thing I wanted to point out to you also from experience is it was a fight case. I told you about the trial where the prosecution lost because the subject minor was so much smaller than the victim. Another case, and this kind of has come up before in terms of what information we want to know. And that is, and I believe one of you pointed out, what was the buildup to the fight kind of thing. Here it's a flag football situation, but as everyone knows, fights happened for different reasons, and a lot of it is what happened before that. And this is the time where you don't erase your common sense. You guys, this is trial by peers, and so you have a wealth of knowledge just from your experience as being a teenager. I know you don't hear that a lot, but it's true. So I want to tell you about a situation. The young lady was pleading guilty to fighting, and she got up and made a statement after her attorney argued, and almost cried because she was talking about how the other girl had said some terrible things. She shared one thing, but didn't want to say the other things about her mom. And she's like, I wasn't raised to talk about people's moms that way. And she really hurt my feelings, and it hurt me because I love my mom. And yes, I did this. Yes, I hit her. And the jury came back with a sentence that was lower than what her counselor argued for. And as the kids are looking back at me like, what the heck happened? That was lower than both of us. My answer is, hey, that resonates with people. Don't talk about someone's mom. I mean, everybody knows that's wrong. Everybody knows that's bad. So there are some experiences that you guys have that are great to use, and don't leave your experience on the table. Put those into your arguments. Do that fact finding and put that into what you work, because you know better than any of us what teenagers will listen to and what they won't. So don't forget that. It's really important that that piece of it come into play as well. Okay, so we hit 12:30, so I wanted to open it up to questions, unless Mike has something to add.
Real quick before we open it up to questions, this is our first time doing a virtual class like this with this class structure. So you guys probably have a little bit more experience with virtual classes than the three of us do, just with how the end of the school year went for a lot of you. I'm sure you're very familiar with Zoom. So if you guys have thoughts on what went well, what didn't go well, maybe thoughts for improvements, if you guys want to send those to the Gmail that Mike gave out, I actually don't know it off the top of my head.
You can send it to, honestly, you can either send it to Katya, or you can send it to the CCLF training. That way we all have our eyes on it.
But we would really appreciate it if you guys would take a couple minutes. If you have those thoughts, just send them our way. We're figuring this out just like you guys are with the virtual classroom. So Christian, I see your comment. We're working on it. But if you guys want to send those via email, because you guys have a lot of thoughts and this group chat is not permanent. So if you send it via email, we'll be able to see it and remember it and take note of it.
Okay, what's Kahoot? So I'm a big nerd. I have Discord. If something like I know we have email, but if you guys, and you can email me this if you don't want to talk about it now, but if you guys want me to set up like a Discord or something like that, I can do that. Just fair warning, I'm not going to tell, my setting is off, so you're not going to see what game I'm playing. But I can set something like that up if it'd be easier. That way we all see all the questions. I mean, the email's great too, because that way we can all kind of keep track of it. But if you guys want a Discord server, I can chuck that up. I'll have to teach Patrick and Katya how to use it, but I'll be on it. Hey, do you have anything else you want to add about that?
No, just you guys are being very patient with us as we do this, and that's awesome, and we really appreciate it.
Give me your pen. We'll get to the questions here in a second, but I just want to say a couple of closing remarks. Number one, first of all, quiz with a competition. I like that. All right, so I'll look into Discord and Kahoot for this week. So before we get into questions, I want to say a couple things. First of all, excellent job today. We were all a little nervous on how this was going to go. I'm very impressed with absolutely everybody. Great job participating. Great job sending questions in. Very impressed. The next thing I want to say is this.
I'm going to talk over you to point out another issue that you guys did really, really, really well. And I want to give a huge shout out to each and every one of you of the 68 of us that are on here. Nobody ever talked over anybody else.
Except you.
Just now.
But that was to point out how nobody did that. And no, that's awesome, you guys, because I know we do court by remote video conferencing, which is similar to this, and there are grown-ups that talk over each other, and so you guys have really shown a lot of class today not doing that. So I interrupted to say, good job for not interrupting.
The rule, you will learn, if nothing else, in the next 4 weeks, that the rules apply to everyone but Miss Quinlan. So, but that's why we're friends. Anyway, getting back to the point, it's come to my attention that there's been some discussion, I don't think by anyone that's still on here, but by some others, that they were a little intimidated with the amount of work and homework and this, that, and the other thing. So I want to emphasize again, even though we just said it, you guys so far extremely impressive. Felicia and I and Patrick have been texting each other kind of as class has gone on. Lexi and I have talked a little bit. Absolutely impressed. So you guys can do this stuff. I know it's a lot of work, but I don't want you guys to get intimidated by it. Remember, you can always reach out to us. We'll see if we can get the Discord thing set up. I'll do it after class today. And I can send out, I'll have Katya send an email out to everybody. But just remember, we're training you guys to actually take live cases. So the amount of work you're going to be putting in to the homework that we're providing you is about as much, if not, it's probably in some cases it'll be actually less than what you'll do in real life. So you'll have to I just want you guys to know, don't be intimidated by it. We're training you guys to do this stuff in steps. So this week was all about case prep. What we used to do in Trial by Peers was you as a 4-week class, 2 days a week, and each class would be a separate topic. So if you think this is, if you're feeling overwhelmed, like you're getting too much information, this is actually a little bit less information than what you gave me before. So we really want to focus on how to, like by the end of this class, I should be able to hand you a case file and you'll be most likely at least ready to go with somebody helping you out a little bit. So don't feel intimidated. Don't feel like you can't do this stuff. If there's no real wrong, like we said today, there's no real wrong answers. So if you have an idea about homework, like don't worry about whether or not the answer is right or wrong. It's about thinking about that question and how you're going to apply that. This coming week's homework is going to look really intimidating. I'm going to be honest with you, because Felicia is giving you essentially bar prep questions when we took the bar. All right. Cutting me off again.
Yeah, no, I know. I was trying to wait so that it would be ironic that I only interrupted you to talk about interrupting. But I did have more to say about next week.
Okay.
So, because I wrote that homework and I don't want you to all hate me. So, but I did want to make sure that before we go on to what's going to happen next week, I did want to make sure that any last questions about case prep, because this is a really practical week where you guys pretty much did what you would be doing for most of your cases. If there was anything that got missed, because we've had some great participation, we don't mean to miss anything, and I want to make sure that everybody's questions are answered. No? You mean we covered everything?
I think we were.
How was the subject minor determined? That's a really good question, Christian, and so I'm going to answer that. The subject minor is the name that we have given the defendant in the case. So it's whoever's charged. Mike, do you want to chime in on why we call the defendant the subject minor?
I will, but since we're transitioning over to questions, just one last thing. Don't give up on stuff. I'm just going to give you guys a little bit of encouragement. You guys are doing great. As far as the subject minor, we're trying to avoid, so if you're in juvenile court or an adult court, you're a defendant. And we're trying to focus, remember why we're here. It's about, excuse me, it's about restorative justice. And if you call someone a defendant, we don't want to give everyone the idea of like they're this big wrongdoer, because, you know, perception's reality, and sometimes people prejudge. By calling them a subject minor, you're focusing the fact that they're minors. They're still kids. They still have a lot to learn. Mistakes happen. So in the realm of restorative justice, we're trying to avoid language that makes it sound like they're wrongdoers. You know, they're participating in this. They're voluntarily participating in this. They could have went to the juvenile justice court and sat there as a defendant and had a real life public defender and a real life prosecutor in court with them. But this is more of a, I understand I've done something wrong situation. So that's why we call them subject minors. I mean, in the realm of the fact that the you know, a criminal court case, technically speaking, they are defendants, but we want to focus, us as a program and you guys as counselors want to focus on them as, remember what I said at the first orientation, who's the most important person in the room? It's the subject minor, because our goal as prosecution, defense, judge, senior attorney is to make sure they don't come back in the program.
Okay, I want to answer in the order we got them. The burden of proof in trial by peers is the same as in real life. It's beyond a reasonable doubt. It's everything that you saw in Law and Order and other very, very reliable TV shows, because we all know TV is super reliable. It's beyond a shadow of a reasonable doubt. There's actually, when we go to trial, there's actually a jury instruction on it. So that's what you're looking for. You have to prove it beyond a reasonable doubt. Let's see, what was the other question?
And to elaborate on beyond a reasonable doubt real quick, not to cut you off, but wow, we're terrible. You guys have been great at not cutting people off, but the instructors are just talking over each other now. Beyond a reasonable doubt is the highest standard of proof. It is 99% sure, if not 99.9% sure. You guys might have heard of different standards of proof. One is, oh my gosh, I'm blanking.
Clear and convincing
No,
evidence.
the lower one.
Preponderance.
One is the preponderance of the evidence. That's 51%. Beyond a reasonable doubt is way higher. So if you're the prosecution, you're going to have to prove every single element 99%. If you're the defense, that's a really high standard for the prosecution to meet. So you want to poke holes in their elements, in their arguments. You don't need to poke holes in everything, just one. So the standard of proof is beyond a reasonable doubt. That's 99%. So just wanted to add that on to Felicia's explanation.
We're going to get into this more when we talk about trial prep, but Lexi brought up a good point, and I'm going to give you an analogy. Criminal statutes are like baking a cake. You either have all the ingredients or you don't. So to kind of tack on to what she said about if you're the defense, if you've got 5 elements in a case and you can cast a lot of reasonable doubt in one of those elements, do that. That in a criminal case, that will most likely win your case if you can convince the jury that one of the elements didn't matter, because you have to have all the elements or it didn't occur.
You don't have cake.
Then you don't have cake. And let's be honest, who doesn't want cake? Angel, that's kind of correct, but kind of don't, or kind of not, just because sometimes it is from the standpoint of the degrees mean there's a different circumstance with which, so like first degree murder is a higher, like you have to have premeditation, whereas lower degrees, they don't have as stringent of things. However, that does change your analysis. So you wouldn't want to charge someone with first degree murder if you can't prove that they were premeditating, because that would completely eliminate your ability to do it. And I've seen cases where people are charged with the wrong thing or they have a wrong, someone sues them for the wrong argument, and then they go into court and they're bashing away at that one thing. That's like, well, you're charged. They may have been guilty of statute B, but I'm charging them with statute A, and that means they're not guilty.
Lexi, can you help with that question about number 8 on the outline?
Yeah, hang on. I'm going to go down to it. I mean, question 8 on the handout is just the standard of proof in trial by peers cases is blank. The answer to that is beyond a reasonable doubt. And I wrote those, so I apologize if I didn't do a good job of following the video. Hopefully the next ones are a little bit more clear when you're trying to fill out the blank. So if anyone has any more cases about what beyond a reasonable doubt is as far as the standard of proof goes, you can put them in chat.
Okay, CQ, tell that I didn't write that, so I didn't know what the question was for question 8.
All good.
That's why I need you. All right, what's your question about Ronald? Don't wait till the end. Do it now.
We're almost at the end.
You can hear me, right?
Yep.
Okay, so I had a couple questions, and I just wanted to clear the confusion. So in the statement report for Michael McKinney, he states at the end, Kenny was like, "You be lying all the time." Then he got mad and pushed me and hit me in the face. So I just want to be clear, it's Kenny who hit him at the end? Because it seems like, yeah, sorry.
You're good.
Well, so here's the thing. If this was a real life case that had been assigned to you, you would have the opportunity to discuss that with him to clear it up. So just remember that. So you're going to have to kind of, when we read these examples, if their things aren't clear, use them as a way to argue something. Maybe you can say, well, it's not clear here, so what really happened? If you're depending on what side you're on. And the other thing is, remember, these are just statements made by each witness. So they're going to cast things in the light that's most favorable to them. So, or not witnesses, but parties. So, and this is something that sometimes, even now, I'm a little guilty of it, is, just because someone said something doesn't mean it's the actual truth. So you need to look and see. In this case, it's kind of hard. You really just have the two statements back to back. So it's like he said, she said. So you really need to look and see if you've got any corroborating evidence that you can use for their statements. So, but that's a good thing you picked up on, because it's not clear. So maybe they go into court and they say something different. You're like, okay, well, what story is true today? You know what I mean?
And sorry,
go ahead.
Also on the arrest report, someone wrote next to affray, it was amended to disturbance. So is affray higher than disturbance, or?
I don't know if it's necessarily higher. It's just different. Now, if you get this case handed to you, you see that, you want to ask, you want to ask Katya. That's something that you ask Katya, right? Like, hey, which one is it? Because you don't want to prepare your whole case for one sentence. And then I've actually seen that happen in trial by peers as an accident. And if I remember right, we continued the case because both sides prepared the case for, statute A, and then come to find out it was a clerical error. And it's like, well, no one's really prepared. And you don't want to violate someone's due process by they're not prepared to discuss that specific charge. So that's happened before.
Okay, thank you.
Oh, and I'm being reminded, and this is why Patrick informed me that we switched affray to disturbance. So these case files that's why that switched to that. So there's your answer. Thank you, Patrick.
I want to really quickly go over hold open agreements, because someone asked me about it and I kind of answered it, and then someone else said, well, what is that? So basically, a hold open agreement under the law is where you acknowledge some responsibility but you're given a set of terms like community service, maybe some counseling, paying a fine, and then the charge is actually held open until you complete all those things, and then the charge will be dismissed if you complete all those things. And the reason we don't negotiate those for the trial by peers program is that basically that's what we're doing. Because the charges will be dismissed off the juvenile record, once they complete all of the trial by peers requirements, these are essentially all hold open agreements. So that's just a term under the law that somebody obviously knew and wanted to use. And I wanted to just reiterate, basically, everybody gets that. So you're just basically now negotiating or arguing the terms of whatever the hold open agreement is going to be. And then I want to make sure there's no more questions before I give you a brief kind of.
There's one question where I'm actually going to have Patrick answer it because I'm not 100% sure of the answer. I could take a guess at it, but I don't want to be wrong. Nicole asked, what happens if someone doesn't show up for court or mediation? And I'm pretty sure while Patrick's on, it really just depends on the circumstances, I think. But I'd like Patrick or Katya to chime in on that so we know.
9 times out of 10, we will send that back. Like you just said, it just all depends on the circumstances. But if we get no call, no show, those basically are going back. At least we got to have some type of response from our client. But if we do not have any movement from them, we will send it back.
And I think I know Lexi's answering one of the questions in chat right now. So unless there's anything else, I think we can kind of start discussing next week.
I'm going to, this is Katya. I'm going to be sending out the assignments and everything for next week on Monday.
Katya, can you answer about sharing the video or the recording?
I'm actually going to try to upload it to the YouTube channel. So this is, I have no idea how, I have litigation services is providing the service to us. So I'm going to have to get it from them. So as soon as I get it from them, I'll try to upload the link up to our YouTube channel.
Okay, so I wanted to give you just a quick, the homework tomorrow is going to, the homework next week is going to be a little bit different than you guys did today. Tomorrow, or next, sorry, I keep saying that. Next week is going to be a foundational week where you're going to learn about the law that we're going to be using, criminal law, criminal procedure. Some of it's, I think that's all very interesting and fun. That's why I'm a lawyer. But you may struggle with the homework, and I just want to tell you, just answer to the best of your ability. We're going to go over every single question. You're not going to fail if you get too many wrong. Don't worry about that part. It's designed to make you think about these concepts, and it's designed to make sure that you understand kind of the lawyer way of thinking. So, and putting that in the criminal law, criminal procedure module was the best way to get you guys to start thinking like that. We're trying to train you. So I don't want anyone to get very disheartened and throw any books at the table or throw your computer. Just go ahead and answer how you would and leave all of your devices unscathed. And if you are disgruntled, you will feel free to let me personally know that when we do our Zoom meeting next Saturday, because I will own all of it. It's my fault. But I'm very excited to see what some of you guys come up with answers. They're all multiple choice. So you have a 1 in a 4 chance of always being correct. So don't worry.
Is there a reason you were giggling, Felicia?
I wasn't going to say anything. I'm just saying, don't hurt anything.
So a couple things. First of all, I have a suggestion while you're doing the multiple choice, and it's in the spirit of thinking about it. If you feel that you need more information to make a determination on that, then write a note down. Because what's going to happen is we're going to talk about those questions on next week, which I got to be honest with you, we went through them and there were a couple I was like,
yeah,
I don't know.
They're not easy.
Yeah,
and we're saying that as people who took the bar exam, they are not easy
Yeah.
questions. Felicia really amped up the difficulty on those questions. So don't feel bad if you're like, what is going on here? Because I did that.
Yeah. So, but if you think of things in other scenarios and other situations or you need more information to answer the question, write that on the side, because in real life, court and cases are not multiple choice. So don't get frustrated. And Felicia was giggling because during bar prep, when I was answering questions, I got upset one day and some of my devices didn't make it through unscathed. So if I'm getting frustrated, there's a sign. But don't get intimidated. You're not going to get them wrong. If you guys, Melissa, know, it's just a matter of, knowing the material. You're not really supposed to get them all right. So if you guys have questions about it and you want to talk about it, feel free to reach out, but do not think we're expecting you guys to get these things right. It is literally just so you start thinking about it. Because when we come next week, what we're going to do is we're going to look at a question and be like, okay, this is what that question said. What if we change this fact? Now, how does that impact it? So, yeah, what Felicia said, you can review the statutes, but don't go do independent research. You don't need to Google stuff. You don't need to go crazy making sure you're right. It's not what this homework is about. It's just to get you to start thinking about it. That's it. So I just want to make that crystal clear. Do not get frustrated. If you are getting frustrated, go take a walk.
Yeah, take a break.
Yeah, you don't need to sit there and do it. It's really just, it's not to be right on this. No one's really going to sit there and grill, oh, you only get a 70%, you're done. Don't think like that. So I have nothing else to add for the week. I'll let the ladies close out.
I don't have anything else to add either. You guys did really, really well for this class. I was really impressed with all the discussion, and there was a lot of discussion happening in group chat, which is really good to see. So keep it up, keep working on it. Don't put it off until the last minute. This is not something you should put off until the last minute, and I'll end with that. Felicia, I don't know if you have more to add or not.
We'll let you have the last word.
No, I like Lexi's last word. That's brilliant. Just leave it there. Don't put it off till.
Well, like I said, if you guys got questions during the week, there's the CCLF training Gmail. I will, at some point between today and tomorrow, set up a Discord server. I will look and see if I can figure out what Kahoots is, because I'm old. Maybe I'll let you do that.
I actually did Kahoot for my class reunion the other week, so I kind of know what it is. So I will look into that, I guess.
Yeah. And, like I said, great job this week. Good luck on the homework. If you got questions, please reach out. And thanks, everyone. Have a great Saturday, and have a great Saturday.
Thanks, guys.
And you guys can all cruise out now. You don't have to stick around.
No, you guys can leave.
Thank you.
Bye.
All right, bye, guys.
Saturday. Bye-bye. Let them go.
So Discord is like, you're done, right?